Welcome back, everyone, as we talk with Patrick Macqueen, real estate attorney in the state of Arizona, and we're wrapping up some of the title conversations, and I guess I have a couple of quick questions and some scenarios that I come across, and it's always interesting as we talk about the ownership of the property and the titling when we get scenarios where we have kind of this blended set of borrowers, right? So, I'll oftentimes have a case where you've got husband and wife. Wife may have great credit, husband has a lot more income, can't be on the loan. So, I've got a case where the husband's mother and father-in-law are co-signing with his wife, right? So you've got one of a married spouse couple on title, and then you've got her parents that are also married. And when you start putting these things together, kind of what are some of your thoughts to say, okay, how do we structure this from the title aspect so that we're making good choices and leaving people with some reasonable options, let's say.
Well, as a side note, one of the first cases I ever worked on 20 some years ago was a situation in which the lender goofed up and didn't get the correct people on title, etc. The loan was invalidated in that situation. So
Wow.
basically, these people got free money. And you don't see that anymore, right? This was a very long time ago, but they
That
were
loophole
using
closed.
yeah, exactly. They were using the incorrect parties, etc. And so it ultimately, based on some statutes, etc. But to answer your question, the what you need is that separate agreement that we talked about.
Okay.
Whenever you've got a situation where people are residing in the property but don't actually own it, or are on the loan but aren't, but don't actually own it. I mean, there's all sorts of scenarios that you can come up with.
Hmm.
The in-law type of situation. It is imperative that you have this agreement that says, look, if there's a divorce on this end, this is what happens. If there is, if mom wants off title, if mom wants off the loan, this is what we're all going to work towards getting a refi, etc. Because I've seen moms and dads, uh, older brothers, whatever it is, stuck on loans, and stuck in a situation where their credit now is being impacted by something that the actual owners are doing. And so it is, as a lender, yeah, you want to make sure that all of the ducks are in a row, and you've satisfied the obligations to, check this person's credit and to make these things happen. But on a practical level, when we're talking about the actual people who are involved in this situation, very, very important that they understand, the risks, of co-signing and those types of things. So it can be very, very risky. I get questions probably once or twice a month that says, hey, I signed for my son on this document, whether it's a lease, whether it's a loan, whether it's something else, and he's goofing around and he's not taking his obligations seriously. And I say, well, I'm sorry to tell you, but there's nothing I can do because this is your obligation too. So, having a separate agreement that addresses these types of situations, can be very beneficial.
Yeah, I think that's really kind of the step one is just going through all those scenarios and then taking that document that's sort of drafted from the parties involved and bouncing that off of, you know, you so that you could, look over the document and make sure the language makes sense, make sure the scenarios are such that they're they're clear cut enough that they make some sense, at least to provide some framework if there is a challenge going forward, right?
And to also kind of say, hey, did you think about this? Did you know that this is a possibility? Have you
Right.
thought through these next couple of steps? Because oftentimes the parties will be able to put in there, hey, this is what we want. This is our arrangement
Yeah, here's
now.
our goal.
Here's
Here's
our
where we'd
goal.
like to go. Yeah.
Exactly. And then it's like, well, okay, this actually can't happen because under law, this is how it's going to play out or whatever. And so have you thought about these types of situations? Really, that's where most people who come up with an arrangement like that are sophisticated enough to understand the basics of it. But sometimes, my job is to forecast future stuff, and sometimes that future stuff isn't great. And so it's like, well, hey, did you actually know that this is what's going to happen if X, Y, and Z don't happen? Oh, okay. Well, I guess we need to include some additional language here or remove this language, whatever it is. So always a good idea just to run that by somebody just to make sure it encapsulates everything it is that the parties are intending to do.
Okay, and one question, because I see quite a bit of titling done in the name of a trust. So is that something that do you recommend that if they have a trust, and how do you do that if you're holding title and investing it in different manners? Can you like the tenants in common, can they each have their own trust and hold their portion in a trust, or what are some of your you know guidelines there for people?
Yeah, a trust is a good idea. It's a great estate planning tool. There's some trusts that have creditor protection. Those are very expensive trusts, but yeah, I think having title in the name of a trust is always a good idea. And yes, you can have a tenant in common interest owned by a trust or held by a trust. And so ultimately, what that does is it allows for the seamless sort of continuity and continuation of that investment by at least that one tenant's in common interest that's held by the trust, because you get a new trustee that pops in, or the trust addresses and possibly avoids probate. So yeah, I mean, I think holding in the name of a trust is a good idea. And unlike a situation in which we convey an interest to an LLC, which may trigger a due on sale clause in loan documents, which is a concern of some people. Yeah, right. The conveyance to a trust it cannot, right? Under federal law, there's a law that says we want to promote people doing proper estate planning, etc. It won't trigger the due on sale clause if you just do it to a family trust that is maintained by the actual borrower. So
Okay.
so yeah, so trusts are another good way to hold property. LLCs, similar, you can do it through an LLC. Now you might not get your lender to actually buy off on you conveying the property to an LLC or holding title in the name of the LLC. So some people will skirt around that because again, the due on sale clause may be triggered by that conveyance. What we're doing in the lender's eyes is violating the deed of trust, because under the deed of trust it says any transfer of the property means that we as the lender can now call this loan due. And if you don't pay us when we call it due, we can initiate the foreclosure, et cetera. So
That's when bad things happen,
that's when
typically,
bad
right?
things happen. Yep,
Yeah.
exactly. So yeah, so holding it in a trust is usually a very good idea.
So just generically, as I'm thinking through this in my head, so you know, I'm married, my wife and I want to take title to a property. We'd probably pick community property with rights of survivorship, and we also have a trust. When would you pick one over the other?
I would pick the trust.
Okay.
In that, I would likely pick the trust in that situation, because the trust is going to deal with what happens when you're both gone. The
Okay.
community property with right of survivorship only deals with one of you being gone. And so the
So if
trust
you're
will,
both in a plane crash together, right?
yep.
Okay. Okay. That makes a lot of sense. Yeah, I just wasn't sure. And so on the trust, it sounds like um maybe you wouldn't, you know, you'd probably pick the trust. I guess it sounds like you'd pick it over not having it, but if the deed already has the right of survivorship on it, like the joint tenants with rights of survivorship, it probably you can't play around with that, right? I mean that it's either or.
Uh, yeah, you couldn't have both the trust and the joint tenancy. Just
Okay.
it wouldn't work. You couldn't take the property as a trust as a joint tenant. It Yeah, you'd ultimately have some litigation likely.
Right, right. Because now you've sort of it's like a mixed message, right? Like you said go to A and now go to B, and it gets confusing. Whereas if it was, tenants in common, obviously, if you had that percentage share ownership into your trust as your owner, that's very clear. And you're not muddying some of the waters. Sometimes I see sole and separate deeds, and I'll see things like unmarried man, unmarried woman. Um, do those have any real significance other than they're just trying to specifically address the marital status of the owner?
They address the ownership status if there is a ultimate dispute between husband and wife. So
Okay.
uh, in you may see sole and separate designation um, when somebody brings a property to the marriage, or when in-laws grant a piece of property to one of the spouses but not the other.
Hmm.
So in those types of situations, the person will take sole and separate property, because remember what I said earlier on, everything is presumed to be a community asset, right? It's
Right.
ours. It's our joint pot, right? Well, you can actually own sole and separate property, or your own property, but you have to be very clear in making that designation. And usually the other spouse, the non-owning spouse, has to disclaim any interest in that sole and separate asset. So let's say that my in-laws wanted to grant my wife a property, but didn't want to include me on that. What they would do is they would grant her that property as her sole and separate property. I would then need to sign a disclaimer deed as well, disclaiming any interest in that property. And the same goes for property that, I bring to a marriage. If I want that to be mine upon death, upon divorce, I need to make it very clear that this is my sole and separate property. And, my wife would have to disclaim any interest in that property.
And how airtight is a disclaimer deed as far as like a legal instrument? Are those pretty tight? Like, can you change your mind and undisclaim, say, wait a minute, I changed my mind. I don't want to do that. I don't want to give it away. I know it's yours now, but things change over time, or I have financial contributions as the disclaimed spouse, let's say. Uh, does it hold up, and can you change it?
It usually holds up.
Okay.
I haven't seen a lot of litigated situations in which it didn't. Now, there could be some argument out there that says, look, we said this was sole and separate, but we've always treated it as community. I mean, look at the bills, look at who's maintaining it, look at all of these things. I didn't do this stuff just for free. I didn't do this for nothing. And so you could probably have a situation in which that designation is deemed irrelevant, but I would say that would be pretty tough to do. I mean, you could have enough commingling of the asset and that sort of thing to lose sole and separate status, but I think the general rule is going to be that's a strong designation, and it's going to be upheld absent some incredible circumstances.
Okay, great. Yeah, just always interested to know, how well these
Well,
things actually hold up, right?
us as lawyers, we can make up some pretty creative arguments if we have to, and when pressed on those types of things. And so, there's probably a 1 in 10 chance that you could make this argument and a judge would buy it. And so, again, it's a showing you're going to have to make, but it's a pretty incredible showing that you're going to have to make.
And if they both agree that, hey, it's no longer sole and separate property, right? They would just go and they would modify and they'd get a new warranty deed and they would put it into, whatever classification, let's say they both agreed to at that point, I assume.
Exactly.
Okay. And can you help people prepare these deeds and get them filed and recorded in the counties that they're supposed to be in?
We do it all the time. Yep,
Okay.
we do it all the time.
Just want to make sure. Have I missed any of the types of the classifications, or is there anything that you wanted to add to some of the ways in which title can be held, at least in Arizona?
No, I mean, if people want that worksheet that I mentioned at the beginning, they're welcome to have that. But we hit everything
Great.
in terms of real estate law, and frankly some family law, and frankly some estate planning law. So I think that was a very comprehensive look at a simple but potentially complex issue.
And I think it's one of those, this is one of those topics that just gets overshadowed and sort of thrown off to the side as if it's inconsequential just because of the way that we transact real estate typically in Arizona compared to some of the other states, of course, that are attorney states, right? In those states, we know that those all of the deeds and the vesting is at least being examined by the real estate attorney in every transaction. But that's not the case here. So I think keeping people aware of that is fantastic, just so that they know what the options are. And, again, thank you so much for all of your expertise and the time on these topics. Information is fantastic, and I really hope that we can help, our fellow Arizonans mitigate some of the potential risk that they have by, taking some action and finding the right vesting for their situation, even if that changes, knowing that they can reach out to you to get some assistance, to look at some of the drafted paperwork to lay out some of the rules of the road for the different parties involved, I think is really important. And just want to, again, thank you and direct people maybe to your website so that they can throw questions at you or shoot you an email or give your office a call to make sure that they can contact you and just have some of that confirmation. It's really cheap insurance to make sure the vesting is correct, is the way I look at it. Because unwinding this stuff, when I've seen it happen, is it's almost always a pressure situation, right? Somebody's selling a house, somebody's passed away. They didn't understand it had been quit claimed 4 times in the last 3 decades. And now we've got, a clouded title. We have all these issues. And meanwhile, the buyers haven't done anything wrong and they're not closing on time and there's problems.
Yep, there you nailed it. I mean, that is the situation. If I have to file a quiet title action because somebody goofed up their title work, you better hope there's not a lot of defendants and everybody plays nice, because otherwise it's going to take a very long time and be very costly. So
Yeah.
getting it right the first time is incredibly important.
Great. Well, thank you again. Have a fantastic day, sir, and we will talk to you again soon.
Awesome. Thank you, Carl.